Completely irresponsible and unprofessional. That is the only way I can describe the Home Affairs Ministry's announcements last week regarding the raising of the TSMIT to $70,000. And I'm not talking about the 482 visa and 186 visa requirements here. I'm talking about how that announcement affected the 491 visa holders and their aim to apply for permanent residency through the 191 visa. We are also talking about those who have in fact already lodged their 191 visa application and the 491 visa applications. Hello and welcome to this special edition of Australian Immigration News, and I'm Karl Konrad. This program is brought to you by Australian Immigration Law Services right here in Sydney. We know the Minister talked about the rise of the TSMIT and the 482 visa. However, the problem is the Department announced back in September of 2019 that the income requirements of the 191 visas was to be set at the same level as the TSMIT at $53,900. The minimum income threshold was identified to be linked with the TSMIT. The announcement stated the minimum taxable income for the subclass 494 and 191 visa will be set at the temporary skilled migration income threshold, the TSMIT, unless concessions are agreed, such as in relation to Dharma. The TSMIT is currently set at $53,900. You can find a link to that reference, which is still on the department's website today. So naturally, when the minister announced a huge jump in the TSMIT, the 491 visa holders began to freak out. And then to make matters worse, if you go to the department's website to check the 191 visa requirements, it says this: your taxable income must be at least at the minimum income threshold. Your taxable income is shown on your Australian Taxation Office ATO Notice of Assessment. We will list the relevant regulatory instrument for that income year. You must have met the minimum income threshold for at least 3 income years. Well, incredibly, there is no information to be found on the Immigration Department's website regarding the 191 visa of what the minimum income threshold is actually set at. And remember, this is a visa which has been open to the public and been operating since November 2022. In fact, people have already lodged their 191 visa applications, but nowhere can you find what is the minimum income you are supposed to meet. What we do have is this announcement back in September of 2019, and clearly there is a link to the TSMIT. Even thinking about applying for the 191 visa takes careful planning, as the overview page of the 191 visa indicates on the department's website. You must have had a taxable income at or above the specific income threshold for at least 3 years while holding your eligible visa. This means, of course, the 491 visa holders have to plan more than 3 years in advance so they can be sure to meet the minimum income threshold for the 191 visa. But according to the website, we don't even know what that is. Well, I'm sorry to say, if you think this is all bad enough, unfortunately, it gets worse. When you examine the regulations for the 191 visa, which you can see on the screen now, this section requires you to have earned a specific income level, highlighted here. The applicant's taxable income for each of those relevant income years is at least equal to the amount specified in an instrument under subclause 3 in relation to the applicant. And subclause 3 states that the Minister may, by legislative instrument, specify an amount for the purposes of subclause 2 in relation to all applicants or different classes of applicants. Unfortunately, the problem is there is no instrument in existence that uses the 191 regulations as its authority. This is unprecedented in the last 24 years of my experience. We have a visa subclass open since November 2022. The regulations released since April 2019, a full 4 years ago, and no one has bothered to make the instrument so the 191 visa can be assessed. So those of you who have lodged their 191 visa applications in the regional stream and wondering why you've not received your permanent residency yet, this is the reason. Without this instrument existing, no one can meet Regulation 191.22. In fact, we've had many comments on our channel wondering why they have not received their 191 visa yet, and indeed has anybody. If you look at this recent FOI result showing that no 191 visas have yet to be granted in the 191 regional stream from when it opened in November last year till the end of February. Now it is very likely that Claire O'Neill and Andrew Giles have no idea about the regulation details I have just described. And let's face it, they are not migration professionals who know the intimate requirements of visa regulations, and they have only been in the job for 12 months. I'm sure Claire O'Neill had no idea about the storm that she was going to create about announcing that huge rise of the TSMIT. They rely on ministerial department heads to brief them on the problems that exist in the system. Well, one thing is for sure, nobody seems to have mentioned this monumental stuff-up. So, can they make this instrument now? Well, of course they can, but what are those who hold the 491 visa and those who are waiting for their visas to be granted? We can only expect that the minister will not tie them to the rise of the TSMIT as being the minimum income threshold required. They should keep it at the same level of $53,900 to be fair to everybody. We will remind the department that these people have moved to regional Australia, obtained jobs to be sure they meet the minimum income level threshold, and have done the right thing. To increase the income level without a significant grandfather clause would be an unconscionable act. If they want to increase this minimum income threshold at all, then it must only apply to those who have not even lodged their 491 visas. When a visa applicants come to make an application for a provisional permanency residency visa, such as this 491 visa is, the applicant must be made fully aware of what will be required of them to reach their permanent residency. You cannot shift the goalposts during the middle of a game. We know the ministers are decent people and will not be letting their department's heads make decisions which will harm visa holders. In this case, the 491 visa holders and those who have lodged 491 applications. Well, that's all for this special midweek edition of the news program. We will be back on the weekend with our regular edition, and then after that we'll be looking at the recalibration of the points test in a next special edition. We are sure the Minister will make an announcement to address the issues raised tonight in the very near future. As always, take care out there, and I'll see you next time. So bye for now.